Following the Supreme Court's decision overturning Roe v. Wade this summer, the battle to protect life in the womb returned to the states, with disappointments like in Kansas, but victories as well, with trigger laws going into effect. And in addition, when Indiana passed the first statewide abortion ban since the Dobbs decision was made. Clearly, challenges remain for the pro-life cause as we now work state by state to protect life. And joining me now to discuss the legal challenges, the legislative challenges, and the decisions happening all over the country is Erin Hawley. She's the senior counsel to the appellate team at Alliance Defending Freedom, who helped the state of Mississippi draft the merits and reply briefs for the Dobbs case, which overturned Roe. Erin, thanks for taking some time for us today.
So glad to be here. Thank you.
Well, first, just from a high level, tell us how you would describe what has happened in the states since Roe was overturned.
Well, it's really been just an amazing time in the pro-life movement. We are seeing state after state being able to protect law. There's a couple of different buckets of sort of state protections that are coming online. The first bucket is what you referred to as trigger laws. So trigger laws were efforts by states who said, we want to protect life. We believe that life is valuable in the womb. We believe that every child has a right to life, that life is a human right, and we want to protect life. However, the outrageous Supreme Court decision in Roe versus Wade forbid states from doing this. So what state legislatures did is they said, in the event that Roe is overturned, our state law will protect life as follows. And so these were called trigger laws. When and if Roe was overturned, as it was thankfully in the Dobbs decision, then these states were able to protect life. So
Erin?
we had 13. Yes.
You were anticipating my question. Go ahead and tell me how many states there had those.
So absolutely. So 13 states had these trigger laws, and most of those have gone into effect. Some have been enjoined by courts as we work out those legal battles. But 13 states protected life with trigger laws. Then there were about 9 states that had what were known as pre-Roe regulations of abortion. And so these states kept on the books laws that protected life. Roe said those were unconstitutional, so they were unenforceable. But after the Supreme Court, again, thankfully overruled Roe, then these state laws came back online. And so the group I work for, Alliance Defending Freedom, is helping states defend both their trigger laws and their pre-Roe prohibitions of abortion.
And you explained well what the trigger laws are, how those worked, and we are today grateful for the lawmakers in those various states who had the foresight and the courage to take up the cause, even when they could not be confident that these laws would ever go into effect. And now lives are being changed because of that. But you mentioned that in some of those states, courts have enjoined the trigger laws from going into effect. What's going on in those states? Why would a court be able to stop a trigger law from going into effect when the Supreme Court has already said Roe versus Wade is no longer valid?
So absolutely. So it's an abuse of judicial power for these various state lower courts to prohibit states from protecting life. And the way they're doing this in many states is that lower courts are finding a right to an abortion in state constitutions. While states are perfectly free to give additional protections, some give additional liberty protections, for example, there really is no basis in any of these state constitutions for finding a right to an abortion. As Justice Alito's opinion explained so coherently, there's nothing about a right to privacy that would include the right to terminate an unborn child's life. That's different from every other right that the Supreme Court or any other state court has recognized. So this idea that a state's right to privacy might protect a woman's right to an abortion is something that the lower courts are making up and are making the very same mistake that the United States Supreme Court made in Roe versus Wade.
And Erin, my assumption is, and my belief is, that these trigger laws exist in more conservative states. We're talking about red states. But now you're telling me that there are courts and there are judges within those red states that are stopping these trigger laws from going into effect. So is that the situation where we are in very conservative states still dealing with progressive judges who in many cases are making the same mistake that the Supreme Court originally did in Roe?
Absolutely. And in several of Alliance Defending Freedom's cases in Wyoming and North Dakota and other places, that is exactly what has happened. You've had lower state court judges who find this right to an abortion in the state constitution, making the very same mistake that the justices did in Roe versus Wade, and taking away the power from the legislators to protect life. As Justice Alito explained, this is so damaging to the democratic process. The state legislators in many of these states, all of these states that have a trigger law, have said that we want to protect life, that life is worthy of protection. And yet, once again, we have state courts and judges finding a way to sort of subvert legislative intent and to allow this right to an abortion that takes the life of an unborn child.
And in some states, I know these judges are elected and have been elected by the people, which is just another reminder of how important some of these local races are that feel obscure when we pick up our ballot, but in the long run can have a really big impact. But Erin, in these cases, we know that it took 50 years to overturn Roe versus Wade. In these state battles where a judge has enjoined the enforcement of these trigger laws, are we going to have to wait 50 years in those states for these issues to be solved?
Absolutely not. So these states are defending vigorously these laws. There are a few states that have pre-Roe laws on the books in which the governor or the attorney general has declined to enforce these laws. But in that case, legislators, Wyoming Right to Life and other groups are stepping in to defend the laws. And they will go up, I think, rather expeditiously to the state Supreme Courts. And we'll hopefully see some good results. In Florida, for example, the Florida Supreme Court, in a decision in the 1980s, found a right to abortion in the Florida Constitution. But that right was based on Roe versus Wade. Now that Roe is gone, I'm hoping that the Florida Supreme Court will revisit that. The Iowa Supreme Court, in a case litigated by one of my colleagues at ADF, found exactly that. They found that a prior Iowa court was wrong to find a right to an abortion, that it did not exist in the Iowa Constitution. And I think a faithful reading of these state constitutions really gives you that result. There is no right to an abortion anywhere in the Constitution's text or structure or history, even when you look at state constitutions. And so the state legislature should be allowed to protect life.
And it looks like we may have lost the connection. Erin Hawley is on the road, and we were as she's catching up with us from the road there in Missouri, and we are thankful for her doing that. I think we're going to work on getting her connection back. We got her back. Erin, thank you again for hanging with us. Now, what I was saying...
Sorry about that.
No, it's okay. It's the wonders of technology. We're thankful that we get you in the way that we can, and we will endure the technological challenges here. But I think the evidence is clear that the lawyers are going to be very busy in the states because of this. But it's not just the lawyers who are going to be very busy. A lot's going to happen at the state legislative level as well. Legislatures have already gotten active. I referenced the vote that happened in Kansas, which did not go well for the life cause. States like Indiana are taking up legislation. Other states are responding in the political way, which they should, and that's the body that should be making these decisions. But what's the landscape across the country in the state legislatures?
So I think it's really hopeful. As you mentioned, for the very first time in 50 years, states are allowed to protect life. We know so much more about a baby's development than we did when Roe happened. We know that babies likely feel pain at 15 weeks or even earlier. And the state legislators are able to take all of this knowledge and evidence and use it to protect life and to explain to constituents, voters themselves, can tell their elected representatives, we believe that life begins at conception. We think our state should protect life. And so that really is a key battleground here.
Now, Erin, now that this does go back to the states, there are some challenges in the pro-life community because there are issues. There are challenging issues within the pro-life legislation and within the pro-life community. Should women be criminally prosecuted for having an abortion? Should exceptions for rape and incest be included in this legislation? How do you see these questions playing themselves out in the states that a majority of the legislature does want to protect life?
So I think there's some answers to some of these questions. And you mentioned women, for example. Alliance Defending Freedom believes that women are the second victim of abortion, that abortion always harms one life. It takes that life, but it also harms a second life, and that the abortion industry has preyed upon vulnerable women who are in a difficult situation, and that states now have the ability to come alongside those women and provide them with the resources and support they need to flourish during pregnancy and beyond, to offer adoptions and also support if they choose to parent. And so some of those things I think we'll see state legislatures, as far as I know, no state is seriously considering, and certainly no state has a law that criminalizes the woman. They go after big abortion, after Planned Parenthood and other providers. And then there's other issues that states are going to work out on sort of a state-by-state basis, as states determined how they can be the most protective of life that is feasible in each state.
Now, we're talking to Erin Hawley with Alliance Defending Freedom. And Erin, we've got a few minutes left here. But I know even in the red states that have either trigger laws or they have pro-life laws, and they are in effect now, one of the challenges for protecting life has to do with chemical abortions and the transition that the abortion industry has made. And essentially, these are pills that are being sent through the mail. In some cases, you're hundreds or thousands of miles away from the person who prescribes them and sends them to you, being sent across state lines in the mail, so they're not traceable. What are the challenges? How are states who want to prevent abortion from the moment of conception dealing with this technological challenge?
Absolutely. That's a huge enforcement challenge. And as you mentioned, these are coming across state lines. They're approved by the FDA up till 10 weeks, so much later than a number of states. States have protected laws much sooner than 10 weeks. So this is a direct violation of a number of state laws. And states have the authority to ban the intrastate shipment of harmful substances, certainly substances that would kill one of their unborn citizens. And there's also, it's really interesting, there's actually a federal statute. It's called the Comstock Law that bans the interstate shipment of abortion pills. This law was unenforceable under Roe, but it's also still on the books. If DOJ wanted to do something good, this would be a really good law to enforce. I don't see them doing that, but I do see a lot of states moving to enforce their own interstate shipment. Just the idea that you cannot bring harmful substances into the states. Those laws should be enforceable.
Erin, probably the last question, about a minute for this one. We've talked a lot about what states are doing well, but we know in a lot of other states, some blue states, are moving the opposite direction to really incentivize abortion. What else are we seeing?
Absolutely. So even after the oral argument in Dobbs, when we saw for the first time that might actually be possible for states to protect life, there have been a number of blue states that have moved to what they call codify Roe, but actually goes much broader, allowing abortion for any reason at all up until the moment before birth. These laws are extremely egregious. They're extreme. They go beyond the laws of every European country and almost every country in the world. And my hope is that now that Roe is overturned, we can actually have the serious conversation. Do we want to be a state? Some of these liberal states, do we want to be a state that allows abortion for any reason up until birth? And it certainly seems that the humane answer to that is no. So I'm hoping some of the blue states will reconsider some of these extreme measures that have been passed.
Yeah, we certainly share that hope. But it is interesting to see how the country is polarizing on this issue, and we saw the different ways we lived with masks for many years during COVID, and it appears that that scenario is developing on abortion as well. But Erin Hawley, thank you so much for pulling over and taking some time for us today.
Thanks for having me. Appreciate it.